Hi everyone, good morning. This is the first in a series of lectures on sales. This is one of those lectures that I will be conducting online. Okay, now the topic is warranty against hidden defects and encumbrances upon the thing sold. Okay, now says here that the vendor shall be responsible for warranty against hidden defects which the thing may have, and should they render it unfit for the use of which it is intended. Okay, now we come to the concept, okay, of warranty as to a particular purpose and as to a general purpose. Right? Usually, warranty spoke of here is usually for a general purpose, like for example, shoes are meant to be worn, okay? Cars are meant to driven in road, and planes are meant to fly. Okay, that's the general purpose. Okay, and should they diminish in its fitness for such use to such an extent that had the vendor been aware thereof, he would not have acquired it, or would not have given a lower price, which said vendor shall not be answerable for the path defects of those which may be visible, those which are not visible, if the vendor is an expert. Okay, so here a defects ought to be latent. Okay? That means they are not observable. Figures as the engine of a car or a plane are considered to be latent because you cannot really observe that at the onset unless you have the plane do a run up or the car do a test drive. Okay? Alright. 1562, sale of goods. Okay. Okay, this being reasonably fit for such a particular purpose, especially if the seller is, as he represents himself to be, okay, an expert, and the buyer relies upon the seller's skill or judgment in purchasing the item. Okay, so there must be a reasonable fitness to perform such a task. Like, what a reasonable fitness to perform a particular task? For example, bicycles are not all the same, right? Some are actually built for road racing, paved road racing. Others are built for non-paved or off-road racing. So if you sell a bike and you say that it was been modified for off-road racing when by its original design it is supposed to be for road racing, then you relied upon the seller's opinion or representation as for the particular purpose. And if they cannot perform that particular purpose, then there is a breach of warranty. And if there's a breach of warranty, just account for action for damages for breach of warranty. Okay? Now, second paragraph is when a thing is bought by the buyer based upon the description of the seller and using that kind of goods. Merchantable quality. Merchantable quality is that this for general purpose. Okay. Now, sometimes items or goods have certain kind of technological mm, advanced signature, you know? Like for example, running shoes. Some shoes have certain kind of technology which makes them lighter, stronger, and much more efficient than other shoes. Okay. Now, when you sell an item under its patent or other trade name, like for example, Klimakul, that's a trade name. Okay. There's no warranty as to its fitness for any particular purpose unless there's a stipulation to the contrary. Okay. In short, why is it so? Because buyers are not really aware of the latest technology. So they do not consider that in buying a shoe, right? But however, if it forms part of a contract and it's supposed to perform a certain kind of task efficiently, then breach of that warranty to perform a certain task, okay, is a breach of warranty against hidden defects, regardless of the reason why. Now, Article 1564, implied warranty and condition as to the quality or fitness of a particular purpose may be annexed by usage or trade. 1565, if a contract is sale by sample, if the seller is a dealer in goods of the same kind, there is implied warranty that goods shall be free from any defect rendering them unmergeable. It should not be apparent unreasonably examination of the sample. Okay? Now, vendor is responsible for the vendor for any hidden faults or defects in things sold, even though he was not aware thereof. The provision will apply if the contrary has been stipulated and the vendor was not aware of the hidden faults or defects in the things sold. Okay? Now, so the attachment of the warranty, as stated in Article 1566, okay, is negated whenever there is a stipulation, okay, that claims that there's a waiver of warranty against hidden defects. Okay, and that the vendor was not aware of the hidden faults or defects of the sold. Okay, this is to protect the good faith of the vendor. He is not fully aware. Knowing that he is fully aware of those defects, he will not sell them in commerce. Now, Article 1567. Articles 1561, 62, 64, 65, and 66. The vendor may elect between withdrawing from the contract and demanding a proportionate reduction to price with damages in either case. So, 1561 to 1561, 1562, 64, 65, and 1566 are actually special grounds to have the contract rescinded. Okay? Not because of damage to a particular person, but there's a possibility that the damage can be suffered by the buyer, okay, if he purchased the contract, or at least a demand for a reduction of the price with damages in either case. Okay. Now, again, damages will only affect if there is no waiver, and then that the vendor is actually aware of the defect. It says here, However, even though he's not aware, he can still be made liable. Okay? Because he is supposed to know the defects of the items that he sells. He's the first to inspect them, so a vendor is still liable. Okay? Now, Article 1568, if a thing sold should be lost in the consequence of hidden faults, and the vendor was aware of them, he shall bear the loss and shall be obliged to return the price and refund the expenses of the contract with damages. Okay, this is self-explanatory. Loss here is a loss that we usually understand as either legal or physical loss. Okay. Now, 1569. If everything sold had any hidden fault at the time of the sale and should thereafter be lost by fortuitous event through the fault of the vendee, the latter may demand that the vendor price which he paid less the value which the thing had when it was lost. Now here, okay, the reason for the loss, okay, is presumably the defect. Okay, but there is no damage here because it says here that it is by virtue of fortuitous event. Okay. Or that the loss took effect at the fault of the vendee. So there. However, damages will set in if the vendor acted in bad faith. Okay. Okay, all the provisions 1569 up to 1561 applies also to judicial sales. Okay. But of course, judgment debtor will be the one who is liable for the judicial sale and not the court or the sheriff who conducted the sale. Okay, usually 6 months is the period in which you should file a action for breach of warranty. Okay, that's written in Article 1571. Now, the prescription regarding breach of warranty are not all the same. No? It's not all the same. Not 6 months. Sometimes it can be shorter. No, especially if it's about animals. It can be about 40 days only, and so forth. Not 6 months. Now, here we talk about animals that are being sold together. Now, animals are unique kinds of personal property because they can sometimes exhibit defects which are not readily seen, which requires testing, not, and of course determination by an expert or a veterinarian. Okay, so that is what we call in law as redhibitory defect. Defects which are not readily seen and hence may require a certain time or period in order for them to be discovered. Okay. Now, 1574 is an emphasis that there is no warranty against ineffective sold at fairs or at public auctions or of livestock sold as condemned. Why? Because they are considered to be sold as is and where is basis, and hence you are fully aware of the defects of the beasts when they are being sold, especially if they are condemned. That means they have certain diseases. You can still buy or trade in animals that have illnesses, Okay, but they are not fit for consumption. They're good for something else. So if animals suffering from contagious diseases shall be void, and the contract shall announce that of animals shall also be void if the use or service for which they are acquired had been stated and they are found to be unfit. Therefore, okay, so there is a void contract here. Not necessarily voidable, but void. Okay. Sometimes contagious diseases are not manifest. Okay. Now, Article 1576, hidden defects of animals, even in case a profession has been made, should be of such a nature that the expert knowledge is not sufficient to discover it, and the defect should be considered as a redhibition. Okay? Redhibitory defects are special kinds of defects, as told by Article 1576. Even experts can make mistakes or in analyzing them. Okay. Now, 1577 speaks about retributory action, as stated in 1576. It is usually brought within 40 days the date of delivery to the vendee. Okay. Okay. 278. Now, the effect of rescission is that you are supposed to return everything, the object of the sale and the price with interest and fruits. Okay. If you cannot perform what is incumbent upon you in rescission and you cannot return the item, then rescission as a remedy will necessarily fail. Okay. Article 1581 speaks regarding form of sale of large cattle because it is written also in the administrative code. The obligations of vendee. These are the provisions. 1582 to 1593. Okay. Now, remember, the vendee can only pay based upon contract, and if there is what they call this insufficient terms thereof, 1582 to 1593, okay, applies primarily. Okay, like for example, when is the vendee exempt from paying the price, or when is the vendee exempt from accepting the thing or object of the contract so as not to be liable for the price. 1582. Yes, agreed upon. The buyer of goods is not bound to accept delivery thereof by installments. However, okay, if there is a contract to the same and it is allowed and the circumstances warrant it, the same can be done. Okay. Now, now 1585 is a presumption, no? That he has accepted the goods when he intimates to the seller that he has accepted them Actually, it's not a presumption, that is an actual general fact, huh? And only goods have been delivered to him. Now, a reasonable time is always a factual question. What can be reasonable in one particular case cannot be reasonable in others. Okay? Examination by the vendee is a condition prior to payment, acceptance and payment. Under certain circumstances, although, the vendee can have this kind of right modified, like COD instances wherein payment is required to be given immediately prior to acceptance or inspection. Okay? So there. Now, sometimes there are instances wherein the buyer refuses to accept a good without just cause. 1588 addresses that kind of situation. And there are instances wherein vendee has to pay interest, which are all enumerated in Article 1589. Suspension of payments, Article 1590. If there's a possibility of a threat, just may be effected from possession of this thing that he bought. Okay? (1591) gives a ground for rescission of the sale if he has reasonable grounds for the loss of the immovable property sold. Okay, this immovable property does not speak about movable property. Okay? Okay. This is about regarding a new term in Article 1592. In case there is default, okay, assuming that the provisions on the Masada law is not availed of, okay, and with respect to movable property, the rescission of sale shall of right take place in the interest of the vendor if the vendee upon expiration things should not have appeared to receive it, or having appeared, he should not have tendered the price at the same time. Now, those are the provisions on the obligations of a vendee. Okay. Now, I hope you enjoyed this and you learned. Now, further discussions on this and clarifications, you can actually message me in the comments and I will refer you to an actual explanation in the book. Okay? Thank you for listening and watching.